our own insight about jurisdiction and procedures for enforcement of rights in Chapter 9. Chapter 9, Section 65. Primacy of customary law practices when disputes involve ICCS or IP's customary law and practices shall be used to resolve disputes.
In Section 65, petitioners insist that claims and disputes within ICCS or IPs and or between ICCS or IPs shall be resolved during customary laws. Consistent with the state policy under the Constitution and the IPRA to recognize, respect, and protect the customs, traditions, and cultural integrity and institution of the ICCS or IPs. They claim that cases of disputes between IPs within the same IP group are always resolved completely in accordance with their customary laws and practice.
Chapter 9, Section 66. Jurisdiction of the NCIP. The NCIP, through its regional offices, shall have jurisdiction over all claims and disputes involving rights of ICC and IPs provide. However, that no such dispute shall be brought to the NCIPs unless the parties have exhausted all remedies provided under their customary law. For this purpose, a certification shall be issued by the Council of Elders or Leaders who participated in the attempt to settle the dispute that the same has not been resolved, which certification shall be a condition prudent to the filing of the petition with the NCIP. In Section 66, the NCIP may excuse their rights, but has limitation. If they exceed their claims and get petition, they have to get a certification from the elders leaders certifies that they have participated the attempt to settle if there any commotion present.
Chapter 9, Section 67. Appeals to the Court of Appeals. Decision of the NCIP shall be appealable to the Court of Appeals by way of petition for review.
In Section 67, petitioners maintain that it is the National Commission on Indigenous People, not the regular court, which has jurisdiction over disputes and controversies involving ancestral domain of the indigenous peoples regardless of the parties involved. The jurisdiction over the subject matter of the care rests upon the NCIP as conferred by the IPRA.
Chapter 9, Section 68. Execution of decision, award, and order. Upon expiration of the period herein provided and no appeal is perfected by any of the contending parties, the hearing officer of the NCIP, on its own initiative or upon motion by the prevailing party, shall issue a writ of execution requiring the sheriff or the proper officer to execute final decisions. Orders to award of the regional hearing officer of the NCIP. In Section 68, the execution of the decision and orders is hereby given by the sheriff or the proper officer if no one make an appeal from any contending parties to avoid conflict.
Chapter 9, Section 69. The NCIP shall have the power and authority.
In Section 69, the jurisdiction of the NCIP in resolving claims and disputes involving IP rights. IPs is not limited to the IPs of the same tribe. Authority to hold any person in contempt, directly or indirectly, and impose appropriate penalties thereof. The IPRA created NCIP as the agency of government mandated to realize the rights of IPs. NICP shall still have power over such claims and disputes even if the practice involved do not belong to the same IP group.
Chapter 9, Section 70. No restraining order or preliminary injunction. No inferior court of the Philippines shall have jurisdiction to issue any restraining order or writ of preliminary injunction against the NCIP or any of its duly authorized or designed offices in any case, disputes or controversy arising from, necessary to, or interpretation of this act, and other formatted laws relating to ICC and IPs and ancestral domains. In Section 70, NCIPs are verdict-free and no inferior court can do that because of their state of living.